All right, good afternoon, everyone, and thank you to the next webinar in the 2023 MSHA webinar series by Maciel Carey. Today, we're going to be talking about managing MSHA in complaint investigations and 105C complaints. My name is Nick Scala. As usual, if you have made a habit of joining us here on these, thank you and welcome back. I am the chair of the National Workplace Safety, or MSHA Workplace Safety Practice Group here at Maciel Carey, where I represent companies around the country in all things MSHA, whether you're an operator or an independent contractor, help you out from just citation contest, compliance assistance, getting programs up and running, and as one would expect, investigation management. And in this case, particularly those investigations related to complaints by employees or by others. So, today what I want to talk about is take a quick look at just general complaint investigations, not necessarily a complaint of discrimination, as we'll talk about later, but complaint investigations in general. What happens when MSHA gets phoned in a complaint that there is a hazard at our site? Maybe you've had this before, maybe you haven't. When we get these, typically MSHA comes out and they're looking at specific items, right? It's not necessarily a full inspection of the site, but it often turns into that, depending on the nature of the investigations and what is found. So, really, when we get safety and health complaints, they're broken down, or at least MSHA breaks them down. And this is the next couple of slides is largely pulled from their complaint investigation handbook series. But MSHA is looking at particularly safety and health complaints, right? And the first one of those is called a Section 103G complaint. And those are communicated to MSHA by a person who identifies as a minor or a representative of minors. And so that's important because when we have this, we're tying it back to someone who is in the industry, who is probably working at that mine or has worked at that mine immediately beforehand. And they are relaying to MSHA concerns they have because of things they've seen, whether it's a condition or practice, et cetera. And, there has to be this reasonable belief that an imminent danger or violation of a mandatory safety and health standard or a violation of the act exists, because not everything contained in the Mine Act is a mandatory safety and health standard. Now, most of the things we think about when we're talking about MSHA violations are mandatory safety and health standards. If it's a guard that's not in place, or it's ground conditions, whether in an underground mine or in a surface mine, maybe it's dump point conditions. That's a big thing right now with MSHA and the continued focus on powered haulage. But there has to be a reasonable belief that these exist by the person who is a minor or is a representative of minors. They need to provide their contact information to MSHA, that MSHA can follow up with them, but that information is not provided to the company. Now, when we have this kind of process, MSHA is going to go through and they're going to evaluate, do an initial vetting of the complaint. And it'll be assigned to an AR, an inspector, probably from the most logically and usual field office over a mine. And usually when they have these, unless there's a question of whether or not MSHA has jurisdiction because it's a complaint that isn't necessarily safety and health related, MSHA is going to come out and they're going to do an on-site investigation. When you have these investigations where a complaint is the justification for them coming out there, you should always ask for a copy of the complaint at the beginning, right? And MSHA should provide to you, if it's one of these complaints under Section 103G, where it's been reported by a minor or representative of minors, they should provide you with, a boiled down version of what the individual allegations are, because a complaint allegation can have one item on it, or it can have 14. And it can be as vague as there's no guarding on anything at the plant to it is identifying specific areas where there are specific insufficiencies. And they do drill that down so that you can't go back and figure out maybe who made the complaint by the specific information included. But if it's a 103G, you should be able to get a copy of that, and then you can review it. And MSHA is going to go down and do an investigation at your site for each one of those items. And they are going to determine whether or not it's a positive, meaning they found, validation to the complaint, or a negative finding, they did not. And in general, MSHA assigns those positive and negative findings not only to each individual allegation, but to the complaint investigation as a whole. And if you have 15 items, and this can be frustrating, and one of the 15 has some merit to it, and MSHA issues a citation for that, they're still going to say that the complaint had positive findings. Because, and I know that we get upset about that as the companies who are subject to that, because we say it was largely negative. It was, in that case, 14 out of 15 were negative findings, but MSHA is still going to consider that a positive in findings for the entirety of the complaint or for that individual item. And when you have a positive finding, you get issued citations or orders, right? That's just the way it goes. These are reviewed internally, so not only just to see what it is, what the complaints are, but also because they're checking to make sure the inspectors are actually running them down and checking them out and issuing enforcement where they need to. So when a complaint comes in, there's a good amount of eyes on it. If it's one of these complaints where a minor has made the complaint to MSHA or a representative of the minors, when we talk about minors reps, you should be getting a copy. If they are refusing to provide a name, or if they are non-minor person who's calling MSHA, you're not going to get that same printout of what was complained about. You're not going to get a list of the allegations, and that's frustrating, but it is written out here that they're not going to provide that information if the person withholds that name or if they are not a minor. It's that is frustrating because we go through this process and I'm just running down a list and we're not allowed to see the list, and that can be somewhat troublesome. In that situation, you should be taking note of what these allegations were as you walk through them with the inspector, because the inspector is going to have to say, I need to go look at this area because there's a complaint, or I need to go look at this. And you can get a good idea of what it is, and we can kind of maybe create our own internal list of what those allegations are, but you are not going to get it. So I've seen this more so in the areas of the country that have a heavier focus on coal, and especially, I know the most of you on the line today are metal, non-metal operators. And where I've really seen this behavior more so is in the parts of the country at metal, non-metal mines where it's former coal districts, and maybe these mines were blurred into a coal office or a coal district. Prior to that, you really always got a copy of the complaint. But down in these areas, it's becoming more typical. At least the trend I'm seeing is that the offices, the reports are either coming in anonymously and they're refusing to provide a name, and when they're doing that, they're not providing copies. So that catches a lot of companies off guard, especially if you're used to the process where there's a complaint, you get a copy of it when MSHA walks in the door. As I mentioned, these are not necessarily regular inspections. They're opened under a different code in MSHA system, but they very much can turn into regular inspections, or at least very widespread inspections. Ideally, we get a list of what the allegations are, and then we can say, well, we can take you directly to this point, and we can focus on that area and keep MSHA targeted, because they're not checking the box on the 2 or a 4 when they're out doing these. This is an additional investigation or inspection. So, we can try and control it as much as possible there, but we know it's MSHA. We know anytime they're on site, or anytime they want, they have warrantless search authority to come on and conduct an inspection at our site. So those can spread, and oftentimes we see them spread if MSHA sees something unsafe happening or thinks they see a violation. That's probably the easiest way to let these grow and extend out beyond the language of the complaints or the allegations that were relayed to MSHA. But nonetheless, if we are getting a copy, or when we sit down and have an opening conference and try and talk to the investigator about what they're coming out to look at and what the allegations are, get them down to that area in the most efficient way, right? You want to drive them straight to it. If you can avoid going through other active areas that are going to take you longer, there's nothing wrong with that if you're going to a specific area and that's what you're trying to see. It's just being efficient with our process to get MSHA there, not for the sake of hiding anything, but just for the sake of wanting this to move quickly, because once we can show MSHA that the complaints are unfounded, that the allegations are unfounded, and get them to put a negative finding on it, hopefully they close out and they move on. And it will save everybody a little bit of headache. There's can be document requests during this process. That's not uncommon. Just like we would on a normal inspection or an investigation, that can be requested, but really they should be tailored. It shouldn't be, I want to see every workplace exam for the last year, unless the allegation is they haven't completed workplace exams in a year. So our response on these is, largely dependent on the allegations that come in and what MSHA is telling us. But, just beware, the same procedures that we usually follow during an inspection are still going to apply, right? We want to take photos of what MSHA takes photos of. We want to, take our notes. We want to make sure that we inform people in our chain of command and in our kind of call tree following the initiation of an investigation that it's happening, because you could very possibly get enforcement. And then if you get citations, everything kind of stems from there, the same as we normally see. So when MSHA gets these investigations or these complaints in the door, they're going to do kind of an initial analysis or evaluation of what it is. And based off of that, they're going to change their response and with the operator or their initial contact with the operator. So, if a minor is complaining or some complainant calls in and says there is an imminent danger at the mine because this is happening, I think it's an easy visual. So on these imminent danger ones, I usually go with someone's working from heights without fall protection. If the AR, the authorized representative, the inspector, kind of does some initial investigation into this and speaks with the individual and they're describing a very specific circumstance, they can simply call the operator, notify them of the imminent danger, and then immediately go out and start doing the inspection. Now, that's tough, because if there's no imminent danger or the activity is not happening, that shouldn't be issued. But this is kind of a unique circumstance where MSHA can kind of put the cart before the horse, and they will go out immediately. If there is a serious hazard or a violation, likewise, they are going to go out and pretty immediately, after speaking with the complainant, conduct that investigation into those areas. There won't be prior notification, but when is there, right? MSHA does not give us prior notification, except for maybe when there is the immediate notification if there is a possible imminent danger. If there's a technical violation or not a serious violation, we usually don't see these, but think like a record keeping, something like that, right? It might be conducted kind of a little more leniency on timing. Maybe they just wrap it up into their next regular safety and health inspection, not supposed to occur in the next week or so. Maybe they just move that up on the timeline. But those ones, they don't move quite as quickly. And I would say, though, those are few and far between. If MSHA's threshold for a serious hazard or a serious violation is pretty low. We know that SNS, significant, substantial, just means that it's, the injury could be lost work days or restricted duty or more serious. So we don't usually see item 3 bore out or scenario 3. And then, the other one is when they don't really move forward on anything because there's no violation based off the complaint, or what is most likely happening here is not within MSHA's authority. So it doesn't constitute something that they have control over. Maybe it's talking about something that's happening immediately off site with, customer truck drivers, or maybe it's talking about some kind of behavior that isn't covered by the Mine Act, another type of discriminatory action or something along those lines. So MSHA will, kind of try to bear this out and try and get some additional information as they go. And if that's the case, they're not going to be coming out on site, or they might try and get some additional information from you because they really don't think the situation applies. Or maybe it's an OSHA site and they're calling MSHA and they're going to determine that pretty quickly. So just kind of the different scenarios that we see play out with these complaint investigations. And, one reason why it's important is because, one, we need to move quickly on them. Two, we need to be careful because, part of the thing that we often see here is people want to know who made the complaint. I'm going to tell you this for the purpose of our next part of this discussion for the next 40 minutes. Don't be too concerned with that. The complaint was made. It was made to MSHA. Deal with it. Go through the investigation process. Hopefully it's all incorrect data and you move through it and you have a negative finding and you move on with your day. But if you're too preoccupied with trying to find who made that complaint to MSHA and possibly taking action against them for making a complaint to MSHA, we are going to have a new investigation that's a lot more difficult to navigate and a lot more unpleasant. And that's going to be a complaint for discrimination or interference under Section 105C. And so MSHA has, like most federal agencies, protections for whistleblowers. Those persons who are going to call the agency or engage with the agency in what is called protected activity, or maybe not even with the agency, but just engage in protected activity. And there is adverse action taken against them. So this is from the Mine Act. It says, no person shall discharge in or in any manner discriminate against or cause to be discharged or cause discrimination against or otherwise interfere with the exercise of the statutory rights of a miner's rep, applicant for employment in a coal or other mine. So there's a couple things to break down here. One, it's discriminate, discharge, or cause discrimination against. Those are kind of what we would usually think of in this situation. Someone does something that's a protected activity within the rights of a miner. We'll just use the example that we've been talking about so far. They call MSHA and they make a complaint. And because of that, if they are discriminated against, meaning maybe they're fired, maybe they're suspended, maybe they're, given a night shift for a month, which is seen as punitive, whatever it might be, that can be discrimination, right? And then they're going to have protections under the Whistleblower Act section of the Mine Act. The other thing that MSHA includes, which is somewhat unique, is this or otherwise interfere with the exercise of the statutory rights of any miner, and that's called interference. And it doesn't necessarily mean that the person engaged in or the person was discharged or was discriminated against, but the actions of the employer made them feel like they couldn't exercise those rights because they would be discriminated against, or they would be discharged, or there would be some kind of adverse action. And in that case, you could still possibly have violated their rights under the Mine Act because you interfered with their ability to exercise those statutory rights. So it's a much less concrete kind of scenario and much more theoretical, and how people feel and how people perceive different decisions or communications from management. But you have to be careful here because, maybe, and again, I'm going to use a bit of an egregious example that goes back to what we were talking about. If someone makes a complaint, you have no idea who it is, but you go and the next day after MSHA does their investigation, you tell the entire workforce, the next person who makes a complaint is going to get fired. Well, that is interference, right? You're threatening an adverse action for someone engaging in protected activity. And that's kind of a really about as cut and dry as you can get there, because you've made them feel like they can't without being discriminated against. So, we usually think these are pretty far away from our normal day-to-day operations. But what I can say is these kind of claims can be very nuanced. And so we need to be careful, one, in how we're addressing them, reacting to them, and beware of what can qualify, because it isn't always discharge. It isn't always termination or discipline or suspension without pay that we get into here. So, we're talking about minors' rights, though. What are some of those rights? These are from a program information bulletin that MSHA put out back in 2010. So it's an old document at this point, but nonetheless, it's a good breakdown of what MSHA considers to be these. So refusal to work when the minor has a good faith or reasonable belief that the conditions are a threat to minor safety and health. So unsafe conditions, refusing to work in unsafe conditions, making a complaint to MSHA about a hazardous condition, or to a mine operator's representative, or a miner's representative. Participate in proceedings under the Mine Act. So if you're contesting citations, if there is litigation going on and you have miners who are going to testify on behalf of MSHA, you can't try and have a chilling effect on that, or stop them from doing it, or discipline them, or discriminate against them for doing so. Having medical evaluations leading to the possible transfer to another job location because of harmful physical agents or pot substances. This is one that we usually don't deal with in the metal non-metal agency or area, but with MSHA's new proposed rule on rust-roll crystal and silica, it could be something that we see more often. So is someone asking to be put on another job because of the conditions in the workplace? And if so, are we, now changing their pay or doing other things? It comes back to Part 90. And Part 90 is specific to coal operations and talks about when we have someone who needs a medical transfer because maybe they're developing black lung, putting them in another job location at the same rate of pay, same everything. And the silica rule, its proposal, I should say, speaks to that you have to do that for someone with decreased lung function, if they cannot safely wear a respirator. But that's also included as a minor's right. So even if it's not directly related to Part 90, or if that provision remains in the MSHA silica rule, it's still considered a minor's right. So if there's a perception that there's a hazardous condition or a toxic substance or physical agent, which could be dust, is probably a good way to look at that. They have the ability to request that, and that is what MSHA talks about very explicitly here as a minor's right. And then, withdrawal or refusal to work because they don't feel like they have the appropriate safety training or the necessary safety training. And then exercise of any statutory right under the Mine Act. So, these aren't absolute. There has to be a good faith concept to them. So, if you have provided the individual with task training, equipment specific training, they voiced that they were concerned with their training, so you had them retrained and talked to them about it, and really kind of did your due diligence and went the whole 10 yards there. It doesn't necessarily mean that the discrimination complaint is going to go anywhere, or the whistleblower complaint is going to go anywhere, but it can still be made. We still have to go through this investigation process. So, kind of just recap, go back through, what do we have in here? We have two different areas covered under this: discrimination, which is discriminating against minors or applicants or minors reps for engaging in protected activity, or interference, which is making them feel like they cannot exercise their rights at some point in the future, but there has been no adverse action yet. There might not be any protected activity even engaged in yet. It's just that they feel they cannot do so in the future. These are managed on MSHA side by TCID, or the Technical Compliance and Investigation Division. When the investigations are completed, they're going to get submitted to TCID for review from the districts. at the district level or the regional level, you have review from kind of the district managers or at least the assistant district managers and regional admins if MSHA has them. Right now, a lot of these regional admin positions are not filled. But there is a lot of eyes on 105C investigations. They get special treatment in that they take precedence over other investigations, whether that's a 110 investigation or other ones. They move quickly, as we'll talk about here. And the districts have a team dedicated to this. It's going to be the same special investigators who maybe are out doing an agent liability under 110, but they're going to be focused on a different animal here, and it's going to be the special investigator. Their supervisor may or may not be involved in the actual investigation itself, but that supervisor will be involved, at least on the back end. You might not see them outwardly. And then they'll prepare a report and recommendations that go to the district, who will review it and make their recommendation as it goes up through the levels and eventually goes to the technical compliance division. And that's when it will kind of move away from MSHA and go into the legal side with the solicitor's office as it continues to move forward, if it does. So, as I mentioned before, this applies not just to minors, but to minors reps, and even applicants of minors. If they're, and the way I've seen this bear out in the past is typically when an applicant feels like they did not get a job because of past protected activity that the new company may know of. And maybe that's because, the safety manager or a foreman or someone in some role at the new company also worked with them at the prior company where they made complaints to MSHA or voiced concerns about safety to operator management on a regular basis. And they feel like that had an effect on whether or not they were hired for a position. That's usually where we see the applicants come into the question. But primarily this is investigations into complaints from minors who are employed at our mine or possibly minors reps. And so, when we go from there, we get into these 105C complaints. And this is from their special investigation handbook, the MSHA. And it says here that these are given priority over special investigation cases. So they do focus on them. I have literally had special investigators cancel interviews and witness interviews in 110 cases because they got a new discrimination complaint that came in. It is in writing and it is in action that they prioritize these and move very quickly. And I think that's a note that we need to keep in our mind throughout this process is these do move quickly. You don't have a great deal of time to sit back and think about how we're going to respond to this complaint. If you are being made aware of a discrimination complaint or an interference complaint and an investigation into those, we need to mobilize immediately. And that's because the time frames are shorter, they prioritize them, so they move very quickly. And there's different aspects to them, and each kind of one of them has their own process that plays out, especially in the process of a discrimination complaint where someone's requesting temporary reinstatement or TR. So, in those, usually when an employer kind of gets themselves into a little bit of trouble, it's one of the most common ways, I guess I should phrase that as, is they don't mobilize quickly enough. And then all of a sudden, MSHA is doing witness interviews and they leave a witness interview and tell you that the complaint's ending, the investigation's ending in 3 days. And if you want to provide a position statement, you can do at that point in time. And you haven't even really done anything other than just field their questions. So, you need to mobilize as soon as one of these comes in the door and start doing, your own investigation, finding out if there is merit there. If there is merit, how do you kind of move forward and, maybe take corrective action, maybe see if it can be worked out with the minor, because you do have the ability to settle these with the minor before MSHA even does the investigation or completes the investigation. So, maybe someone went rogue and there is a mea culpa. Not saying that happens often, but sometimes it does. And sometimes you can just put these away pretty quickly, especially when we're not dealing with, termination. Maybe someone just feels like, they got sent home for a shift and they shouldn't have. And you can work through that and maybe make everyone happy and move forward on without the investigation continuing. But in order to know that, in order to get that kind of clarity to take that action or not, and really formulate our defense, you need to just move as soon as they come in. So what are the elements here? We have to have a protected class, and the complainant is a member of it. Here, we talked about this, and we'll talk about it on the next slide, right? We know what those are: minor, rep, minors, rep, applicants. They engage in a protected activity, some kind of action that is included in the statutory rights of a minor, which is a vague term. They suffered an adverse action, and it is, as I said before, beyond just termination or reassignment. And then there has to be a causal nexus or some kind of connection where the operator knew of their protected activity and because of that took that adverse action against the individual. Now, I will say this is probably, one of the ways that MSHA looks most closely at it is the causal nexus and really the proximity in time between the protected activity and the adverse action. And so, the longer there is kind of, the protected activity at least is alleged that it was engaged in and the adverse action, the stronger is the case that they're not going to find that causal nexus, right? It's difficult to say that, hey, I called MSHA on a complaint investigation last year and then they fired me this month. That's obviously kind of a weak argument. A lot has happened in the middle. But if someone called MSHA yesterday and there's a complaint investigation and then they get fired tomorrow morning, that obviously is not a good look in terms of the kind of the outside optics about now we really have to dig into why were they terminated, what specifically happened, who knew about the call to MSHA, et cetera, et cetera. So, the causal nexus, there has to be that connection there. There has to be knowledge by the part of the operator for a discrimination complaint. But, proximity is a big element, proximity in time, I should say. So we had that minors. We know what a minor is. It's defined under the act. I'm not going to beat that one down. Or a rep, the minor's rep. Not everyone has minors reps, but if you do have minors reps, they are someone who is designated by two or more minors to represent their interest during the health and safety process. Usually we see these in union operations, and usually there's one minor rep, and they have to be involved in every process of the MSHA enforcement. So if there's an opening conference and you call your safety and health rep to be there, you got to call that minors rep as well. And they do the walk with them. They do the closeout. They're involved in the process of even contesting citations. They get a copy of the complaint. So, that is a minors rep. There's a lot of exposure to MSHA, obviously. Pretty much everything they're doing as a minors rep can be construed as protected activity when they're acting out their duties as that designee. So, that is often one that we see in this process. And also minors reps are sometimes the ones that we see coming into play when we're talking about interference. Maybe they feel like they can't perform their duties of the minors as minors rep because of some other practice that the operator is engaged in. And that's actually part of the fact pattern of one of the decisions that's out there, really kind of guiding one of the two frameworks of how we evaluate interference is a situation like that. And then obviously an applicant of minor is a pretty self-explanatory phrase. So, what are protected activities? We got the baseline stuff, right? Workplace complaint to MSHA, participating in an MSHA inspection and talking to the inspector. But it also can be not involving MSHA. Are they making complaints of safety and health issues internally? Are they, either submitting it through a hotline, or maybe they're directly telling their supervisor or the safety rep? That is also, kind of basic and baseline protected activity. Refusing to work in unsafe and harmful conditions, or not receiving the requisite training and removing. So those align pretty closely with what we talked about in terms of minors' rights. under that program information bulletin. But, these are kind of the heavy hitters when we think about, was there protected activity engaged in by a minor? If you have a checkbox next to any of these, MSHA's interest is going to be piqued, right? They're going to be very interested in what the person was doing and what transpired after they engaged in it. And they're going to be looking at whether or not there was adverse action. So, that can be kind of the basic ones: demotion, discharge, failure to hire or promote, denial of pay or change in duties, denial of benefits, poor evaluation even can be considered a form of adverse action. Blacklisting in terms of the person trying to get another job or asking for reference to another position, hostile work environment, harassment. Does the person, which is very subjective, right? Those ones are when we start getting into a lot of analysis and a lot of subjectivity, is when we have someone who's claiming they're being harassed and it's not openly apparent that many people heard them being threatened or intimidated. It can also be just failure to recall on layoff, suspensions, reducing hours, denial of time. I've seen claims where I got transferred and put on a new piece of equipment that I don't think is as good as the old piece of equipment I was on. So what are adverse actions are very much dependent on the person who's making the complaint and how they feel. There's a lot of personal perception of whether or not I was wronged for engaging in protected activity. And, sometimes if people have, a good awareness of, protected activity, adverse actions, maybe they are very familiar with this process and this analysis, the adverse actions can be much more nuanced because, they're seeing if they're being treated differently. So, I guess this is to say, if someone doesn't get terminated, that doesn't mean that's the end of it. There can be a lot of items that are MSHA has found to be adverse action in the workforce, and it doesn't always mean that they got discharged or demoted. It can be maybe they didn't get that overtime shift they wanted, and in that case we have to demonstrate in our defense in the investigation why that was, right? Was the person not recalled from a layoff because 55% of our workforce wasn't recalled from a layoff, and he was in the middle ground of experience and seniority and et cetera. It's just something that we have to look at. But again, we don't have a good argument here unless we do our own investigation and figure out what the person is alleging, and then find out how we can defend that, or if we can justify it to the investigator, because that is who we are. That is our audience, right? We are going through this process, and we are trying to convince this investigator that we didn't take an adverse action, or there was no causal nexus, or there was no operator knowledge that existed between this person's perceived protected activity and their perceived adverse action. So we need to be looking at that closely. And again, when you're dealing with an investigation with a normal discrimination complaint that's closed within about 45 to 60 days from when the complaint comes in, it's moving quickly. That goes by very fast, especially when you have the opening with MSHA, and then maybe there's a gap where they are asking for documents, and then you have interviews, and then all of a sudden you're at the end of that time frame. So here, what is the point? This is essentially what it comes down to. This is the point of the investigation, and it's to obtain evidence that there was a connection between the complaint's involvement in protected activity and the alleged discriminatory act. And it says perceived or real there, and what that is meant to say is someone could engage in a protected activity. Maybe they called MSHA and made a complaint, and then they were discriminated against. Maybe they got fired. Maybe they got, demoted because of youth. That was the case. Or, you weren't sure who did it, but you think it was Nick. You think it was him who made that phone call to MSHA. So you take activity there. So it wasn't necessarily real, but you thought that they had to engage in that protected activity. So it can be both. And that's what they're looking for. Was there perceived or real connection there? There has to be some evidence that the person who took action against the complainant or influenced the adverse action knew or suspected that the complainant engaged in that protected activity. And so that comes down to operator knowledge. So, if someone got fired and claims protected activity, and the decision to fire them or lay them off was part of someone, 4 states away in headquarters and had nothing to do with anything they did on site, there's no causal nexus between the two. If no one outside of that plant knew of what took place, or if no one there even knew what took place, right? Maybe they made a call to MSHA and then everyone at the plant just said, okay, well, that was anonymous, and moved on with their life. So there has to be some connection there with knowledge. It has to be used to establish that there is discrimination. But it's not often one time, right? A lot of times in here, the allegations kind of expand as MSHA speaks with the complainants, and it might be, well, they knew about it because I did this at this point in time, or they knew about it because I did that at that point in time. So we often go in here with a pretty specific, or at least allegation of the protected activity and the adverse action and who was aware of what. And then, this is one of the things that we have to kind of be prepared to field and be prepared to, readjust as we move forward in these investigations. But it's, how is this evolving? Has the investigator talked with the complainant, and now there's, 3 other instances where they're claiming they engage in protected activity, and we don't get notice of that, right? We don't all of a sudden get an updated letter that says, here's a new complaint that says there was 4 more instances. We usually learn about it when we're getting peppered by questions. So, beware of that. Be prepared to tell MSHA if you're not prepared to answer something, and we need to get into a more discussion on it. But if your decision makers are not aware of protected activity, then you can't prove that the discrimination was motivated by it, by engaging in it. So that's kind of an element there. One thing that we need to talk about with discrimination, and we talked about at the beginning that interference is a pretty unique thing in the MSHA world, but so is this temporary reinstatement. And you might have heard of it if you've gone through one of these investigations previously. But temporary reinstatement is a very unique and very powerful tool that minors who are claiming discrimination can request. And the bar for MSHA to pursue it is incredibly low. So, what is it and when does it apply? Temporary reinstatement, it comes up when someone has been terminated from a position or has been demoted or docked pay or something of that nature, where they are no longer in the same position they were, or when they claim they engage in protected activity, or before, I should say, the adverse action took place. It can be, so just let's talk about it in the most basic form, which is someone claims they engaged in protected activity and they were fired. And now they're claiming that was the adverse action. It was discriminatory in the firing. They no longer have a job. So they will tell the investigator, and MSHA will ask them this, do you want temporary reinstatement? And usually you always say yes here, because it is one, either actual returning to your job duty, or 2, it can be economic if the parties agree to it. And that means you're paying someone to essentially stay at home until the investigation and possibly even the litigation is complete, because you don't want them to come back on site. And we see that often enough when we have someone who we know we termed them, but it was for a specific reason that had nothing to do with their engaging in protected activity. Maybe they're unsafe on the site. Maybe they're insubordinate. Maybe they put others at risk. Instead of taking a temporary reinstatement hearing to a judge and having them put them back into their job, and we're required to put that person back in that same haul truck or loader or whatever it might be, we can negotiate and work to negotiate maybe economic reinstatement. But it means you have to treat them, and technically they are back in your employ. That's full pay, benefits, vacation. If there's a wage increase, they have to be included. If there's bonuses, they have to be included. It kind of goes on and on and on. So this is a very strong tool, and the idea behind it is that if a minor was actually discriminated against, it puts them back in their position of being whole while the investigation bears out, while it's litigated, if MSHA finds that they were discriminated against. If that's the case, there is a preliminary investigation that has to be completed within 15 days from the time that TR is requested. That is a very short amount of time. And there'd be essentially some quick review of evidence to determine whether or not the claim was frivolously brought or not by the employee. And if it is found to be not frivolously brought, again, an incredibly low standard, MSHA applies for temporary reinstatement. And so, they apply on the individual's behalf. And because the standard of review is so low, these are almost 99.9% of the time are going to be affirmed by whatever administrative law judge is assigned the case from the Federal Mine Safety and Health Review Commission. So, if we're going to defeat a TR, it needs to happen in that investigation standpoint. And a lot of times, one of the biggest factors here is if there's questions about whether or not a claim was frivolously brought, they're going to look at the proximity between the alleged protected activity and the alleged adverse action. So again, I've said it how many times now, you've got to move quickly on these. Temporary reinstatement being a factor puts that into overdrive. So we have to be prepared in just about 2 weeks to submit a detailed position statement about why temporary reinstatement is not applicable. We need to have done an investigation into the claim and the individual and determined what happened and why. And if we have defenses, what are they to temporary reinstatement claims, and how we can prove that it was a frivolously brought complaint. A unique thing, but a item that demands us to pay attention immediately. And when we hear that there's a 105C claim, our ears should perk up. And if it has to do with someone who's no longer employed with us, be prepared for temporary reinstatement to be part of it and that investigation to move very quickly. We also talked about interference at the beginning. I'm not gonna beat this one down because it is pretty unique and we don't see it very often, but we should be aware of it because it does change our approach. So there doesn't have to be an exercise of protected activity, right? That is an element of discrimination complaints. Protected class, protected activity, adverse action, employer knowledge and causal nexus, discrimination, right? With interference, there does not need to be your protected activity. It just has to be made to feel like they cannot exercise their protected activity or their right to engage in a protected activity. There does not need to be an adverse action. There needs to be a threat of adverse action or some kind of action that makes them feel like they cannot. Therefore, that's the interference, right? You are engaging, or at least the claim is you've engaged as an operator in some kind of act that meant they couldn't exercise this protected activity without suffering an adverse action. There is a bit of a conflict right now in case law in that, there's not a rule that governs, but there's two rules that have been used by the Federal Mine Safety and Health Review Commission and the judges, and unfortunately the Court of Appeals have not given us kind of what rule we have to apply. But it has to do with whether or not there's intent or motive. So MSHA doesn't think it needs to prove operator motive or intent was to interfere with the exercise of miners' rights. Operators think that needs to be part of it, right? Just because someone feels like they couldn't engage in protected activity, that wasn't my intent here. That's essentially the argument here. MSHA says it doesn't matter what your intent is. If a reasonable person thinks it could have been construed as, interfering with their miners' rights, it didn't matter what your intent was. As operators, obviously think that's an important element, right? Unintentional interference versus intentional interference is essentially what it comes down to. So there's two tests that we look at. One does not require that intent. That's called the Franks and Hoy test, and then the other is the Pepin test. And in that one, the actions need to be motivated by the exercise of protected activity. So we have to be trying to interfere with that exercise of rights. Again, it's all very kind of high level because it's hard to put a context to. One of the cases that really governs here, and it's a Franks and Hoy, is talking about if there is bonuses, production bonuses, citation bonuses, could those be used as an interference tool? And then the complaint there was that, and it might, in this one complaint that kind of generated a number of other cases, is that a company had a bonus system in place. That bonus system was tied to production, and so a miner's rep felt they couldn't take the time out to go on an inspection, because if they did that, his team would not meet their bonus metrics, and therefore he couldn't engage in his miner's right to participate in that inspection as a miner's rep. And the company says that wasn't the intent of it. The intent was that we were, trying to incentivize performance. But in that case, the complaint was that it interfered in my rights because I felt like if I went and participated, I would lose out on my bonus program. My teammates would lose out on their bonuses for that shift. So that's kind of an example of where the interference claims can be, especially with miners' reps. In terms of the time frame, as I said, they move quickly. A complainant or a miner's rep applicant has 60 days from the date of the adverse action to file the complaint. If they file it late, MSHA gives them a chance to explain why it was late and has a little leeway there. But if it's 6 months late, I mean, that's probably too late unless they have a really good reason. But so 60 days is a time frame that we want people adhere to. If it comes in late, we're going to argue that it should be tossed out because it wasn't timely. Once that complaint is filed, you're going to have 15 days to initiate an investigation, 45 days to submit a report to TCID. So that means 15 days to initiate, 50 days, 45 days to submit the report. So you're moving quickly. 6 weeks in this investigation is concluding and MSHA's finishing up its report. 60 days for TCID, and that's not an additional 60 days. This is from the complaint date filed to review it. And then, you should be 90 days for the solicitor's office to decide whether or not they want to put forth a complaint on behalf of the miner for discrimination. So, that is a quick time frame, and that's just the general complaint and investigation time frame. When we're talking about applications for temporary reinstatement, they have 15 days to complete their initial investigation and submit their findings to CCID. 20 days, right? So 5 more days, and MSHA has to decide whether or not they're going to ask the solicitor to review it. And then in 30 days from that complaint or for that request for application for temporary reinstatement, the solicitor's office has to file the application or decline to do so. So I told you guys at the beginning, this moves fast. We need to stay on top of things. This is why. So be prepared to respond quickly. You got to move fast. You got to, as soon as you get informed, whether because you get a letter in the mail, a letter by email, or a special investigator shows up and hands you a letter and starts peppering you with questions, which is probably going to be the case, you need to mobilize with your support team. As outside counsel, I think the best time to get me involved is as soon as we know that one of these is kicking off, because that's the best way to get involved and kind of get on things on the ground floor. But the same goes for your upper management, your safety people, your legal teams internally, whoever that might be, so that you can move quickly. If a worker is still employed, ensure there's no retaliation or no further retaliation, whether it is just move on and move quickly and let them keep doing their job. And, we don't want to have a rash reaction create a new complaint. And that has happened before. Conduct your own investigation. Is it a timely complaint? We're going to have to start collecting our own internal documents, as well as be prepared for MSHA request documents. We're going to want to interview our employees, as well as prepare them to be interviewed by MSHA. And then we're going to want to, make some record of what we saw. Like any special investigation, MSHA is going to focus a lot on witness interviews. They'll spend a lot of time offline. You're not going to know about it other than what you learn. But talking with the employee that made the complaint, that shouldn't be a surprise, but that is going to happen. We're not going to see that. We're not going to be part of that. The same rights apply to any interview as we had, whether it's a special investigation or a complaint investigation here under 105C, or a serious accident. Minors have the right to speak with MSHA. They can speak with them alone. They can decline to speak with them, or they can speak with them with anyone that they want present, whether that's a manager, a minor's rep, a friend, a family member, an attorney, etc. MSHA is probably going to immediately request contact information for employees. We're going to have to provide this to MSHA, but we can inform people that we had to provide it to MSHA, and that they can be prepared that MSHA, is going to contact them offline. I've had a lot of companies who, give this list to MSHA, and then within 48 hours, investigators are showing up at persons' houses. Minors never have to speak with MSHA. When they show up at their house, they don't have to answer their phones if they're calling on personal phones. If they want, they can say, I would do this. I will talk with you, but it will happen at work, and it'll go through my work in order to contact me. We can ask that MSHA does this, but for them to honor it, it needs to come from the employees. Management is a little different, but nonetheless, they have the same minors' rights to cooperate with MSHA or to have MSHA go through us. As I said, there's going to be document requests. There's probably going to be more than one, because MSHA is going to learn things as they go. Take those seriously. They sometimes have very quick turnarounds, and when you need to provide them, and they're not realistic at all. So read those closely and be prepared to tell MSHA if you need additional time, or if you need to work on narrowing down those. Then the other element is we're going to have a chance to develop a position statement. This is important because it's our opportunity to get pen to paper on our facts, what we think is relevant, provide information about the complainant, what their duties were, our personnel who might be involved. And, I don't want to sound too cynical here, but, MSHA's out there, they're investigating. They're going to try to get to the truth of the matter, but they're also going to be, oftentimes very much looking at what the complainant's saying, and really, in my opinion, kind of looking at the lens and the statements of managers and others employees as, does that necessarily support what the person's saying? And they're not going to be asking the questions that might alleviate the liability on the side of the operator. So the position statement is our opportunity to do that if we don't feel like we've done it sufficiently, or to reinforce what we've done in our interviews. We should give context to the complaints, or maybe if there's underlying factors, if there's a justification for why they were terminated, regardless of the fact that they engage in protected activity. Maybe they called MSHA and made a complaint for safety and health, but later that same shift they punched their supervisor, and that's why they were fired, or got in a fight with another employee, or crashed a piece of equipment and, and had a positive test in their, post-incident drug testing. That's the information that we need to get out there early and often, and that we need to put in writing for these position statements. We can add additional supporting documentation, but we should be pretty assertive in these, but also, root them in law. And when we are writing these for clients, we're not giving them a one-page document. We have entire sections based to the facts, and then based on legal analysis and how the claims may or may not survive the legal scrutiny that they're going to be going. Because if that's the case, MSHA has to look at these from their perspective, but then they have to get the solicitor's office involved too. Is going to look at, is this a legally supported claim? And so, those are areas that we need to look at, as we go through the process. But the biggest thing is, we got to prevent these before they happen. So people need to be trained on retaliation. We got to manage protective employees. We need to be aware that, we cannot retaliate against people, nor should we want to. We need to know how to respond to complaints. If people are making safety and health complaints, what are we doing? Are we responding to them quickly? Are we documenting our response? Are we, sitting down with people and telling them what we did or didn't do and why we did or did not do that? They need to be conscious of their decisions. And if they do get complaints of a retaliation or interference, they need to effectively be able to communicate that and start helping us break down the appropriate information, quickly in that process. So what do we want to do? We want to make sure that we're training them. We're training our management employees especially, and ensure they know how to properly respond, and that, I think, is very importantly, it's coordinating with legal, whether in-house or external, and HR, because both are going to be a big part of these processes, because this is a unique interlap of MSHA, a lot of specific MSHA law, as well as general employment law. And when I'm working on these for clients, I'm generally got one of my colleagues who's on our labor and employment practice who's working lockstep with me on it, just so that we make sure we're covering our bases there. Again, have a plan in place or a playbook for responding to complaints from the workforce, maybe before they come into MSHA. Again, we just talked about it, but how are you fielding, how are you addressing safety and health complaints, or maybe complaints of, someone doesn't feel like they have enough training or they need additional PPE. What is your process for evaluating that, dealing with that, either getting them the appropriate PPE, maybe they're right, or, educating them to the fact that, you don't need this because of X, Y, and Z. Recognize these move quick and they're different, right? They're not a general inspection. They're not a safety and health inspection. They have a specific complaint, whether it is a safety and health complaint or a complaint of discrimination that the investigator is targeting. So they are much more direct. They are much more focused on those individual elements. It's not a wide spread review of the facility. So we have to take that and we have to respond accordingly, because everything we're saying, everything we are providing, all the emails we're sending, those are part of the investigation file now. So everything has to have a conscious response to it. You just need to be able to, though, kind of circle the wagons as soon as that comes in. I mentioned at the beginning, but a lot of times we see people caught off guard because a special investigator just shows up at the mine, says, I want to talk to, the person who maybe is the manager or the foreman, whoever is kind of being alleged that they engaged in the adverse action. And a lot of times they just sit down and start peppering you with questions. So people need to be aware that when this comes in, we need to hit pause, right? We need to tell MSHA, we're not sure what this is about. Let us review the complaint, and we will contact you with a time for us to sit down and have an interview. Send us any document requests you might have. What information do you need now, if anything? They're probably going to tell you the employee roster, but you are not required to discuss and you do not have to sit for a substantive interview as soon as MSHA catches you off guard. And that's probably one of the areas where we have people most often engage in foot and mouth syndrome, right? Or have an episode of foot and mouth syndrome because they feel like they have to answer questions and they're not prepared. They're caught off guard. They don't know what they're talking about, or they're just trying to justify something that they don't even know exactly what happened. So take a breath, tell MSHA that you got to contact your counsel, you got to contact senior management, you got to let them know what's going on, and that will be in touch. Might not be happy about that, but that's posturing, really. MSHA investigators know that is probably going to be the case when they walk out somewhere and start having these discussions. But you have to be, and your people have to be educated enough and assertive enough to tell the investigator to step back and take a deep breath, because we're not going to dive into this unprepared. So, be prepared. I've said it a bunch of times too, but really, if you're going to use outside counsel or you have in-house counsel, get them involved at the outset, so that they can help you prepare for this response, because these move quickly. And, with temporary reinstatement being an option, obviously that moves very fast, and that can cost a lot of money if it's not handled properly. And likewise, just in general, these discrimination proceedings, if temporary statement is granted and we can convince MSHA in the investigation phase that there was no discrimination, the temporary reinstatement falls away, even if the minor takes a claim on their own before the commission. So, we have to really, those first 45 days, that is crucial timing in these investigations. So we need to treat it appropriately. And, with that, I appreciate you guys sticking on. Apologize for going a little bit over today, but a lot to discuss on this topic. Join us next month, and we'll have another webinar. This one will be paired up with our OSHA team, and we'll be talking about tips and strategies for safety-related incident investigation and audit reports. So it'll be a good one, especially when we're looking at this new MSHA silica rule and all the evaluations and potential testing that's going to be considered as part of that. So we can look at what's going to be included there, and at least under the proposed rule, and start getting ourselves prepared mentally for what we're going to have in the future, and as well as just generally engaging in those audits and reports. Feel free to check out the blogs and track us all across everything that CMC does. We welcome you to do that, and I'm happy to field any questions as always. Just shoot me an email or give me a phone call, and I'd be happy to talk with you. I get that. We covered a lot. I talked fast. So don't hesitate to reach out, though, and let me know if you have a question after you've had some time to sit there and think on this one. And with that, we'll let you get back to your day, and everyone have a great rest of your week. Thank you.